Media law of freedom of information in a few minutes. The United Kingdom Supreme Court Justice Lord Sumption described the 2000 Freedom of Information Act, sometimes known as FOI, which came into force 5 years later, as a landmark enactment of great constitutional significance. It created a statutory scheme enabling journalists to ask for information from public and government bodies which can source important public interest stories. Another UK Supreme Court Justice, Lord Mance, said, "Information is the key to sound decision-making, to accountability and development. It underpins democracy and assists in combating poverty, oppression, corruption, prejudice and inefficiency." All public bodies are obliged to respond to written freedom of information requests within 20 working days. That's 4 working weeks, and are supposed to have an FOI officer and/or a publication scheme. Freedom of information law is regulated by the Information Commissioner's Office, known as the ICO, which is described as an independent authority set up to uphold information rights in the public interest, promoting openness by public bodies and data privacy for individuals. Public bodies can, however, refuse information requests because of absolute and qualified exemptions, and the FOI system is often criticized by media publishers and non-governmental organizations, NGOs, for being over-bureaucratic and giving public bodies legal powers to easily block and deny access to significant public interest information. The Scottish legal system operates its own freedom of information scheme based on the 2002 Scottish Freedom of Information Act, with a separate Scottish Information Commissioner. If a body refuses to respond to an FOI request, journalists can ask for an internal review and can then appeal to the Information Commissioner within 3 months from the last communication of the public authority. The next stage in the appeal process is to the first-tier tribunal, Information Rights. Any appeal must be brought within 28 days of the date of the ICO's decision. If the case needs to be fought further, an application for permission to appeal can be made to the upper tribunal, and beyond that, on points of law, for judicial review to the administrative division of the High Court. The European Court of Human Rights at Strasbourg recognized a standing right to state information for journalists, academics, and NGOs seeking public interest information when carrying out a social watchdog role. Up until the time of writing, these important principles set out in the case of Magyar Helsinki versus Hungary in 2016 have been blocked by case law from implementation in the UK FOI system. Allied to the FOI system is the legal right to environmental information under the Environmental Information Regulations of 2004, and this can enable journalists to research information about genetically modified crops, polluting discharges into rivers, radiation, noise, and environmental issues related to land, air, water, and other natural resources.